So what are some solutions to that? How do we avoid this? Well, one is just to have an agreement, and that is the owners of the property. Now we're looking at the heirs, could simply have an agreement that says that they're going to manage the property in certain ways. That's not an altogether bad arrangement. It typically is a fairly lengthy document, and it will be as complex as people want to cover the various issues that can be covered. It works fairly well if the property is going to be sold fairly soon. That is, if you know that the property is going to have to go on the market within the next 3 to 5 years, having a simple co-owner agreement is not a bad solution. The problem with it is that it only binds the people that sign the agreement. So if you're looking at transitioning ownership to the next generation, all of a sudden now you've got a situation where the next generation has ownership, but they haven't signed the agreement. They're not bound by it, and you've got some people that are bound by it and some that are not. So that if you're looking at multi-generational ownership issues, the simple co-ownership agreement is just not a very effective way of dealing with it. Another way of dealing with the tenancy in common problems is to have title to a cottage held by a trust or a partnership or a corporation. And up until about 15 years ago or so, having property owned by a trust was a fairly common way of trying to keep it in the family. And I still see vestiges of that. I was working with a family, I'm still working with that family that has property in a trust that will not allow for distribution of the property until the death of the oldest living grandchild that was alive at the time the trust that was written. So it was written in the mid-1970s. That grandchild now, the youngest living one, is in his 30s, and it may go on, the trust could go on for another 40 or 50 years. The problem with the trust, though, is that it's irrevocable. That is, you can't change it. You can't amend that kind of trust. And you better get it right the first time, because it's going to be written in stone for the rest of the time that the trust owns the property.